Hello, my name's Danny Goad, and tonight, on July the 31st, we attempted to make a presentation to the Botetourt County Board of Supervisors with a letter rebutting the county attorney's comments from the past two prior meetings. During that time, we were not afforded a sufficient amount of time to read this letter. We were stopped by the chairman of the Board of Supervisors, Max Scotthorn. Today I have several members of the Botetourt Residents Against Child Exploitation with me. The name of our organization is BRACE. If you want more information about the issue of pornography for children that's in the Botetourt County libraries, please go to our website and you'll get all the information that details this at wearebrace.org. The letter begins, to the Board of Supervisors. During the Board of Supervisors meeting on July 17, County Attorney Michael Lockaby presented a legal analysis regarding the ability of the board to remove obscene books for children and teenagers from our county libraries. We asked for some legal analysis of that presentation, and here is our summary. His presentation was an embarrassment. It appeared to consist mainly of talking points from the Pro-Pornography American Library Association and a few historical Google searches. It was shoddy and incomplete to the point of malpractice. One wonders exactly whom he purports to represent. Lockaby began by claiming that the power to make changes to library policy rests with the Library Board of Trustees, stating, "The Library Board continues to make the policies that the library staff implements. The Library Board has the power to make rules and set policies for the exercise of its authority, and this includes developing and implementing policies for the development and retention of books in the libraries." Really? According to the county website, the Library Board is only advisory and has no other powers. The Library Board's bylaws state, trustees provide opinion and guidance to the library director. The power lies with the Board of Supervisors. The supervisors appoint the library board members, control the library funding, and control the hiring of all staff. Regarding litigation, Lockaby attempted to portray presenting pornography to children as a First Amendment right. He cherry-picked a few of the ALA's favorite court cases, and as the ALA does, misrepresented them. For example, he talks at length about the U.S. Supreme Court 1982 PICO case. He uses this to claim that books already on the shelves may not be removed because of their content. But the PICO case was not about obscenity. It was about mainstream books whose viewpoints parents objected to. He brought up the well-known U.S. Supreme Court 1973 Miller case, but only in a vague manner. Lockaby neglected to mention the important part. The court held that obscene materials did not enjoy First Amendment protection. Instead, Lockaby made the ridiculous suggestion that the parents use an obscure Virginia statute to sue the book publishers for selling the obscene books. Why should parents have to do that? The truth is that the Botetourt library staff purposely bought the books because they are obscene. They knew exactly what was in them. Lockaby brought up the U.S. Supreme Court 2003 United States versus American Library Association case, which he also misrepresents. He tries to paint it as promoting intellectual freedom and access to information. It's just the opposite. In 2000, Congress had passed the Children's Information Protection Act, requiring public libraries to install internet filtering software on their computers to qualify for federal funding. The ALA sued, claiming it violated the First Amendment. The Supreme Court strongly disagreed and ruled against the ALA. It was noted that libraries have wide discretion to exclude pornography and other sexually explicit material, and that a library's interest in protecting its minor patrons from harmful sexual materials is not only legitimate but compelling. This ruling basically sets the standards for the rights of libraries to keep out pornography, despite the continued protest and misinformation about that from the ALA. And in fact, libraries around the country are keeping out pornography and removing it when it's found on their shelves without any actual legal problems. For example, in Campbell County, Wyoming this year, the library board implemented a policy to keep out materials that contain obscenity, pornography, and sexual perversions. The new policy specifically cites the 2003 U.S. versus Alabama or ALA case as its basis. And when the library director refused to comply, the library board fired her. A few weeks ago in St. Mary's, Kansas, the library removed a children's book about transgenderism. The ALA whined in the local paper, but not much more. Standing up to the ALA is beginning to happen more and more across America. Lockaby refers to our library employees as professionals who shouldn't be interfered with in their duties. They are only professionals in the sense that they get a paycheck for working in a library. Pornography is considered a terrible public health problem across the country and is particularly destructive to the developing minds of children. Real library professionals would not have anything to do with it. If there was not a narrow loophole in the state's obscenity laws exempting schools and libraries, these professionals would be in jail. Finally, Lockaby brought up the hysterical threats that the county is risking an expensive lawsuit if it protects children by removing pornography from the library. The ALA and ACLU regularly send well-crafted, frightening letters to local governments, threatening huge lawsuits if they remove the pornography from children's and teens sections. Sometimes cowardly elected representatives back down, but it's a paper tiger. It's difficult to name a case that actually went to court. And the reason they trot out the old 1982 PICO case is that they virtually never win. In closing, do not insult the intelligence of the people of Botetourt County by taking seriously such shoddy and absurd legal advice in order to avoid doing your job of protecting the children. And do not pretend that there is no obscenity, pornography, or sexual perversions depicted in the books for children and teenagers here. We have amply shown you that examples of that, and we would be happy to show it to you again. And we do not want your absurd parental controls. We want clean libraries that don't harm children and the people of Botetourt County. We demand remove the pornographic materials from all Botetourt County libraries directed at children. Thank you.